Good evening, everyone, and welcome to the Brian Crombie Radio Hour. Peter Biro is my guest tonight. He is the founder and the president of Democracy Think Tank, Section 1, Senior Fellow of Massey College, Chair Emeritus, and past chair of the Jane Goodall Institute. He's got a new book. It's based on Section 33 of the Canadian Charter of Rights and Freedoms, also known as the Notwithstanding Clause. He says it's one of the Constitution's most controversial and least well understood provisions. Peter, welcome to the show.
Great to be with you, Brian.
What do you want to tell us about the Notwithstanding Clause?
That's a great opening question. Where to begin? Well, what I want to tell you is it's a big problem, and it's a big controversy. And as you and your viewers and listeners know, it's also a big story in the news and has been for some time. The clause itself is a provision that allows governments, both Parliament and the provinces, although Parliament has never used it to this point, it allows them to essentially protect a law, to allow a law to operate, notwithstanding that it may infringe certain fundamental rights and freedoms in the Canadian Charter of Rights and Freedoms. And it does so, and this is the part that's especially controversial, is that it does so without requiring any justification on the part of that government for invoking the Notwithstanding Clause. So that's what's particularly controversial about it. But perhaps if we get into it in some detail, we can look at what is problematic and what's interesting about it in terms of its impact on our civic life, on liberal democracy, on the role of the courts, on the relationship between the courts and our governments, and of course, most importantly, on the civil liberties of Canadians.
So I want to ask you two questions, if I could, and I want you to elevate back for a second. Before we go, we're going to come back to the book and the Notwithstanding Clause in detail and go through it. And I think that it's fantastic that you actually have written and published a book on this topic. But I've had a couple of conversations with people recently where people have been very critical of what's gone on in the United States and the fact that it would appear that someone is above the law. And you know that above the law would be based on a couple of things. Number one, that you don't investigate, charge, or pursue a president while he's a president. So therefore, all these charges against Donald Trump, the former president, formerly charged, have been dropped by the federal government. And then second of all, that the president has the right to pardon people. Two things that I don't think would exist in Canada. And people have been very critical of American system and say, well, you know, it's not true that no one is above the law because someone is above the law. The president is above the law in the United States. And I've heard a couple of times people retort, well, you know what? We're just as bad. We've got the Notwithstanding Clause. So tell me, how can you have a constitution, a Bill of Rights, if governments can, at their discretion when they want to, not agree with them by way of invoking the Notwithstanding Clause? And aren't we just as bad as what we think of the Americans if we've got such a clause that means that Doug Ford or the Premier of Quebec or someone like that is above the law when they want to invoke it?
Well, now you've now really given me an opportunity to plug Section 1, my Democracy Think Tank. The 10th fundamental in my secular decalogue of fundamentals of liberal democracy goes as follows. The best laws, the most robust constitution, and the finest institutions cannot and will not safeguard democracy unless what I call heroic citizens come to the rescue of the democracy itself. The Constitution and the laws and the institutions, however robust and however well crafted they are, and this goes for Canada, the United States, and any democracy or any country that calls itself a democracy, whether liberal or otherwise, depends entirely on the willingness of its leaders to adhere to the conventions and norms, and of course to the rules and laws themselves. And more importantly, it depends on the tolerance, or rather the intolerance, of the citizenry in general for departures from adherence to those conventions, for transgressions. So, I mean, your opening question raises really actually what are the fundamental questions for liberal constitutionalism today, and that has to do with whether we're willing to abide by the principles that ground, all right, that underpin liberal democratic government and a liberal democratic civic culture. And obviously, with that sort of initial response, I'm joining issue with you, agreeing with your premise, and saying, first of all, in Canada, we have no reason at all to be smug about the state of our democracy. By the way, not just because we have a notwithstanding clause, which is problematic, and we'll get into it, but because we've seen in Canadian politics a willingness to depart from adherence to those very important norms, notwithstanding the rules and the laws. We've seen it in many, many instances, and we have a general increasing tolerance for or indifference to those sorts of transgressions by the general population over time. Now, with respect to the notwithstanding clause in particular, I would agree largely with the premise of your question. I think a notwithstanding clause has no place and no part to play in a liberal democratic constitution. But there are others who would disagree profoundly with me, who make very, very compelling cases. And that's detailed in the book, by the way. Very, very compelling and important arguments in support of the notwithstanding clause, arguing that it is an instrument that actually undergirds democracy, that protects, the democracy from the erroneous decisions, erroneous exercises of discretion by the unelected, appointed judiciary, and that it allows Parliament and the legislatures to have the last word on questions of rights. So there are very important questions that we need to consider. So when I say I don't think we need the notwithstanding clause, it's not because I think judges are perfect or infallible. It's because I think we already have an outstanding mechanism in the Constitution that allows for the justification of rights restrictions in a manner and in a way that is consistent with the values of free and democratic society. And that is Section 1 of the Charter, which we may or may not get into in this conversation if you'd like to, so that we don't need Section 33. That's my submission. But I think the premise of your question is very, very good. And might I just add, the United States now is no longer a liberal democracy in my judgment. It is what I call an electoral autocracy. The Supreme Court's immunity decision, the Senate, the Republican Senate's willingness to essentially abandon, not just the Senate, House of Representatives as well, to kind of forfeit altogether, to abdicate their oversight responsibility. The separation of powers is pretty much gone. The advise and consent role that Senate has for confirmation means nothing now, as the senators who are thinking about opposing Trump's nominees have already been threatened with being primaried in the next election. Trump behaves like a king, and he is being treated like a king. And the tolerance for that seems to be very much present. Don't think that in Canada, our political culture is all that far behind.
The U.S. is not a liberal democracy anymore. It's an autocracy. Seriously?
I say that it is an electoral autocracy, even though it has the laws, the constitutions, the institutions of a robust liberal democracy. But you have to look at behaviors to understand what kind of civic culture, is characterizes a society. If you only look at the laws, then you'll think that Russia is a liberal democracy as well. They have a constitution that looks as robust, in some respects with respect to civil liberties, even more robust than ours. It's practices and attitudes that really disclose the true nature of a political culture. So, what Orban did in Hungary, now called the Orbanization of other societies, including the United States and Erdogan. What Trump already began doing after 2016 and is now doing, in a full-blown way. This is the transformation of a society from a liberal democracy to, in the case of both Hungary and the United States, an electoral autocracy. That's absolutely the case. All the instruments of liberal democratic accountability, the independence of the judiciary, the separation of powers, the oversight branch of the legislative, branch of government, the importance of a professional, neutral, and independent expert civil service. All of these things are being torched or promised to be torched by this president. So even though the laws will remain largely in place and the Constitution won't be altered one iota, but the practices are changing, and the tolerance level in society at large for those transgressions or those departures from adherence to traditional norms and conventions, obviously discloses a willingness to go along with the president. And again, as I said before, we have all kinds of examples in our political system and in political practice that show that these trends are actually occurring here as well.
You think that you could apply those comments to Canada, or some of them to Canada as well? Seriously?
Well, I mean, not to the same extreme and obvious extent, but absolutely yes. We have a parliament that many, many months ago voted overwhelmingly to compel the government to release certain documents, pertaining to a particular government program that seems to be rife with scandal. The Prime Minister's office has simply stonewalled, has ignored the will of Parliament. We had a Prime Minister some years ago who, the same Prime Minister we have today, who violated the important principle of the independence of the prosecutorial branch of government when he clearly interfered with the discretion of the Attorney General at that time and the Prosecutor General of Canada in the SNC-Lavalin case. That was a minor scandal. It should have been a major scandal. We have all kinds of ethics issues that arise, and apart from the pundit class, the general population isn't particularly interested or troubled. And the idea that you would simply throw out a government at the next election and bring in a new one is not nearly enough of an accountability mechanism to return us to the kind of robust adherence to principle that you need in a liberal democracy. But I could give you countless examples. I don't want to sort of go too far afield, given our subject for today. But yes, the answer in short is yes. We have all kinds of reasons to be concerned about democratic backsliding in Canada as well.
Democratic backsliding, the notwithstanding clause. What a fascinating conversation. Peter, remind us all, what's the name of the book and where can we get it?
The book is called The Notwithstanding Clause and the Canadian Charter, Rights, Reforms, and Controversies. It was published this year by McGill Queen's University Press. It's available online everywhere. Just plug in the name and you'll see it. All the bookstores, and of course from McGill Queen's University Press as well. But you can get it on Amazon.
We're going to take a break for some messages and be back in just 2 minutes with Peter Biro talking about the Notwithstanding Clause, about freedom, about democracy, about autocracy, about Canada, about the United States. It's going to be a fascinating conversation today, everybody. Stay with us. Back in 2. Welcome back, everyone, to the Brian Crombie Radio Hour. I've got Peter Biro today as my guest. He's the founder and president of a democracy think tank, Section 1. He's senior fellow of Massey College, chair emeritus and past chair of the Jane Goodall Institute. He's an adjunct professor at the University of Toronto Faculty of Law, where he teaches constitutional law. He's a lawyer, he's an educator, he's a writer on democracy and civil liberties advocate, and he's a scholar. He's the editor of the recently released volume of essays, The Notwithstanding Clause in the Canadian Charter of Rights. And that's what we're talking about today. Let's take a second and step back for everyone and explain what the Charter of Rights is. Section 33 of the Canadian Charter of Rights and Freedoms is also known as the Notwithstanding Clause. It's one of the Constitution's most controversial and least well understood provisions. By invoking the Notwithstanding Clause, the government can insulate a law from the strongest order a court can issue, which is to strike down the law because it infringes a charter right of freedom. Some experts have called for a total moratorium on the use of this clause on the grounds that it is fundamentally incompatible with the tenets of a liberal constitutional democracy, while others have defended the clause on precisely the opposite basis, namely that it preserves democracy by allowing elected lawmakers rather than unelected, unaccountable judges the last word on questions of rights. Peter Biro has for many years been writing and speaking about the Notwithstanding Clause and calling either for its repeal or for laws limiting its use and modifying its operation. And he's now written this book, The Notwithstanding Clause and the Canadian Charter of Rights Reforms and Controversies. Canadian Charter, Rights, Reforms, and Controversies, published this year. Peter, welcome back. Why is the Notwithstanding Clause there? What's the history? I understand it was a compromise at Meech Lake or something like this.
No,
No,
not at
before
Beach
that.
Lake.
Before
Not
that,
Beach Lake.
when the Canadian Constitution was effectively repatriated to Canada, it was a compromise, and it was put in place to placate some premiers that were opposed to the idea of a Charter of Rights and Freedoms. Tell me about the history. Why is it there?
So first of all, it was 1981, November 1981, when the deal was finally done, and April 1982 when the charter was enacted and the Constitution patriated, if you will. There are different reasons for why the Notwithstanding Clause was there. The one thing everybody agrees on is that we wouldn't have a charter without the Notwithstanding Clause having been included, because certain premiers, Peter Lougheed of Alberta, Sterling Lyon of Manitoba, among others, insisted that it be there, or there would be no agreement on the charter. Some of them were not entirely opposed to a charter. Others were. There are scholars who, to this day, think the charter is a bad idea and said so at the time. But again, the arguments for the charter were that provincial legislatures, in particular, didn't want to feel bound by judicial decisions on certain questions of rights. Remember, prior to 1982, there was no Charter of Rights. Courts could not strike down laws on the basis that they infringed freedom of expression, freedom of religion, freedom of conscience, equality rights, etc. Now, there are some exceptions to that in the context of human rights laws, provincial and federal human rights laws. But constitutionally, there was no basis on which to have a law struck down because of the infringement. So suddenly, the advent of the charter limits, in a sense, the sovereignty, if you will, the power of legislatures. We moved from a system of what was called parliamentary sovereignty to a system of what we now refer to as constitutional supremacy. The Constitution becomes the supreme law and of the land. And so the fact that premiers were now going to be subject to this kind of accountability before the courts caused a number of them to say, well, hold on, when it comes to rights, we need to have the ability, if we disagree with judicial opinions on whether there has been an infringement or whether an infringement is justified or not, we need to have the ability to have the last word on this question. Now, the justifications for Section 33 are a lot more sort of involved in that and complex. And there are very, very interesting theories about, democratic theories about how courts alone should not be the only authorities on the question of defining rights, understanding rights, enforcing rights. There should be this coordinate interpretation, this coordinate role that both legislatures and courts play in adjudicating questions of rights. But again, it's a little bit more involved than that. But that is that's sort of the guts of it. We wouldn't have a charter without the notwithstanding clause, and Pierre Elliott Trudeau ultimately had to hold his nose and agree to this. I mean, he was opposed to the charter throughout, but he wouldn't have gotten patriation without a charter that included, sorry, when I say he was opposed to the charter, that's a misstatement. He was opposed to the notwithstanding clause. The charter, of course, was his grand life's work, his grand project. So he'd been trying for, more than a decade and a half to patriate the Constitution and to give us a charter. But he understood we weren't going to get one without a notwithstanding clause.
So, when you think about a democracy, it should be that the people decide. And so therefore, if the people decide that the Supreme Court is wrong, why doesn't the people get to decide something different and overrule the Supreme Court? And, from a U.S. standpoint, the reality is, while, lots of people may think that Donald Trump committed crimes, the people reelected him. And isn't that what democracy should be all about? That the people can choose to overrule a judiciary and a legal system if they so choose and elect somebody. And from a Canadian context, you think about Quebec and some of the language laws that I understand are going in front of the Supreme Court, immediately. And if the people of Quebec want to constantly elect governments that put in place bills that, I think infringe upon English language rights, but that the people in a democracy in a majority want to support, don't they have the right?
Well, so you've hit on the fundamental challenge now for liberal democracies. You've identified the difference between a liberal democracy and other kinds of democracies, and you use the word majority. Majoritarianism would certainly support the premise of your question. But in a liberal democracy, we care about minorities as well. We care about minority rights. And so what the charter does is it essentially says, even if you are not part of the majority, all right, you still have certain rights. You may not have the deciding vote on a whole host of policies because the majorities will decide those things, or pluralities will decide those things in the legislatures. But liberal democracy means that the majority cannot override or trench on or infringe individual rights, minority rights. And so the limit that liberal democratic constitutions place on the actions of the majority is to say, okay, we accept that majorities essentially decide the agenda and they govern, but there's a limit to the laws that they pass and the actions that they sanction when those laws or actions cross a certain line. And so that's what liberal democracy really does. The charter says no matter how great the majority will is on a particular issue, the majority can never run roughshod over individual rights. That's the difference between majoritarianism and a liberal democracy. But we now have in the United States, as I said, an electoral autocracy. At best, it is what some people refer to as an illiberal democracy, which is how Viktor Orban actually describes his own system of government now. And that's a system in which minority interests are pretty vulnerable to the will and discretion of the majority. But that's not what liberal constitutionalism calls for.
What do you think is wrong with the notwithstanding clause? Is there an important controversy or unresolved question that you think either legally or politically we need to address?
Well, there are a few. Let me just raise two. And if I were to indicate what I consider to be the most important live issue right now, it arises out of a conflict between two different cases, one coming out of Quebec, the Hack decision. It's the Bill 21 case in which the government of Quebec introduced a law that bans or restricts the wearing and displaying of religious symbols by government employees. And that case decided that while the law did indeed infringe equality rights, religious freedoms, possibly freedom of expression as well, it acknowledged that the Notwithstanding Clause allowed that law to operate notwithstanding the infringement. But what was controversial, or what is controversial in my mind, is that it also said that once the Notwithstanding Clause has been invoked, the court doesn't even have discretion or jurisdiction to inquire into whether there has been an infringement and to grant any kind of relief short of striking down the law. In other words, just to make the declaration that there has been an infringement for the benefit of public education and public debate, or to grant any other remedy, whether it's a costs remedy, whether it's an exemption from the application of the law. Now, on the other side is a case out of Saskatchewan, the O.R. Pride case, which is known as the Parental Bill of Rights case, the case that was introduced as that resulted from the introduction of legislation by the Saskatchewan government requiring schools to disclose to parents of minors those instances in which minors, and it's generally targeting trans kids, required or requested the use of different pronouns. And the court there also acknowledged that the Notwithstanding Clause protects the law, even though it infringes a number of rights and freedoms. But it did say that the invocation of the Notwithstanding Clause does not prevent a court from pronouncing on the infringement. Now, think about the significance of this for a democracy. It's one thing for a government to invoke the Notwithstanding Clause and protect a law from being struck down because it infringes a charter right. It's something else entirely for that to occur without a court even being able to declare that the law does infringe a right or a freedom. From the standpoint of democratic deliberation, public debate, citizens don't have the ability to even argue the case one way or the other when the law comes up for reenactment after the 5-year sunset period, which is required under Section 33 of the Notwithstanding Clause, because they don't have the benefit of the court's guidance on the significance, the extent, and effect of an infringement. So you've got these two competing views. Saskatchewan says just because a government invokes the Notwithstanding Clause doesn't mean that people can't still go to court and ask the court to declare that there's been an infringement and possibly to make to grant other relief short of striking down the law. And the Quebec case says, nope, once it's been invoked, we don't even get to ask the question, has there been an infringement? And this is profoundly significant for democratic discourse. And by the way, there's a sunset clause in the Notwithstanding Clause in Section 33 that says that the enactment of the Notwithstanding Clause sunsets, it ends, it expires at the end of 5 years. The idea behind that is to give Parliament and the legislatures the opportunity to deliberate and to debate the question again before reenacting it. Imagine doing that without there ever having been the benefit of a judicial opinion, if you will, on the significance of the act and its effect on rights.
So I guess one of the questions I'd have then is when should you be allowed to invoke the Notwithstanding Clause, assuming that it's still there? I think that it's one thing to invoke the Notwithstanding Clause after a court or even the Supreme Court has issued a ruling. It's a whole other thing, which I've seen recently of premiers saying they're going to use the Notwithstanding Clause when they initially propose a bill, like right up front, such that you've never got any chance to argue about whether it's unconstitutional or not. What's your thought on that?
So, of all of the sort of controversies around the use of the notwithstanding clause, you've hit on the one that most people, that's sort of top of mind for most people. And it's referred to as the preemptive use of the notwithstanding clause. And that goes to the issue that I was just talking about, right? Because if you can preemptively invoke the notwithstanding clause, then it goes into effect, it operates, and it has whatever effect it may have on rights without us ever knowing what effect it has on rights, because a court, as you rightly said, hasn't had the opportunity to entertain an application for some kind of declaration. My own personal view is that it should never be used preemptively, but as it is currently drafted, as the text of Section 33 currently reads, there's absolutely nothing that prohibits or precludes preemptive use. So a number of people have been talking about, proposed reforms to the notwithstanding clause. In my perfect world, we would simply repeal it altogether, but that would require a constitutional amendment. But short of that, certainly everyone agrees that it shouldn't be used preemptively. And in fact, I've talked with a number of people who were there back in 1981, 82, who were involved in the negotiations that led to the enactment of the charter, who said that nobody at that time contemplated the possibility of preemptive use. Had they imagined that it would be used, it might be used preemptively, they would have definitely inserted a provision in Section 33 that prohibited that. So one of the proposed reforms is to eliminate preemptive use. And you can do that in a number of different ways. You could just say that directly, or you can say that it shall not be invoked until a court, and in some people have proposed until a court of final appeal, meaning the Supreme Court of Canada, has pronounced on the rights issue. So that's definitely one of the important reforms. There's some others.
Would that not need all the provinces to agree in a constitutional amendment?
Well, they can do it in different ways. Ideally, it would occur through a constitutional amendment so that no province, and including Parliament, no legislature, including Parliament, could change their mind about it later. All right. That's what happens if it's a constitutional amendment. But it could also occur simply by having each legislature enact legislation, which essentially says, and only binds that particular legislature, that says these are the new operating instructions for the notwithstanding clause, and one of them is no preemptive use. But of course, that makes the law and the measure vulnerable to the future will of that same legislature, who may change its mind and say, no, you know what, we're not going to abide by this rule anymore. By the way, another rule that has been proposed is that to make this to confer on it somehow more legitimacy when it is used, is to require a super majority of the legislature that's enacting the notwithstanding clause, that's invoking the notwithstanding clause, a super majority rather than a bare majority.
Well, and I think that you think about corporate law, that would be the comparable, wouldn't it? Is that if you do have major corporate changes, you got to get 66 2/3% to vote in favor, or in takeovers, sometimes it would be 80%. And so therefore, I do think that there's some examples in corporate law that would suggest that kind of supermajority is completely appropriate.
And I agree completely. But unfortunately, as appropriate as it is, and as compelling as that argument and that position is, it still can't be imposed by a court. That's a requirement that has to be agreed to by the legislature that will be bound by it down the road. Either by way of a constitutional amendment or by simple legislation.
I think that one of the big issues that I've got in this whole thing is I always thought that no one would use it. It's one of those things that's there that would be sort of the third rail if you used it in politics. It would be something that you would be embarrassed, ashamed, that you would never want to be a premier or a legislature that would actually invoke it. Let's take a break for some messages and come back and ask Peter why that's not happening. Why is it almost accepted now? Stay with us, everyone. Back in 2 minutes. Welcome back, everyone, to the Brian Crombie Radio Hour. My guest tonight is Peter Biro. He is the founder and president of a democracy think tank called Section 1. He's recently written and published a book called The Notwithstanding Clause and the Canadian Charter: Rights, Reforms, and Controversies. And we're talking about it tonight. And I think this is actually a really important question, and I really appreciate you joining us tonight to discuss it. Because, on this topic, I frankly agreed with the notwithstanding clause when it was suggested, invoked by I guess by Pierre Trudeau when Pierre Elliott Trudeau, when it was the Charter of Rights was instituted. But I was very proud of the Charter of Rights and glad that we had invoked it. I remember getting a copy in a little red folder of the I don't even know, Charter of Rights and Freedoms, and being very proud that Canada finally had such a document. And I remember the conversation at the time was, but no one's ever going to use that notwithstanding clause. It's going to be so, it's going to be like saying I'm a crook if you ever use it. I'm against the law if I use it. And so no one, it's there for emergencies, but no one will ever use it because it's going to be admitting that I'm a crook, but I'm okay with being a crook. I'm okay passing a law that's somehow illegal, according to the Charter of Rights and Freedoms. But now it doesn't seem like it's a problem at all. Legislatures preemptively say we're going to pass this and we're going to invoke the notwithstanding clause, and the population doesn't seem to care. If anything, they're supportive of the use of the notwithstanding clause. What's happened such that, what was it? 1982. You said that I think myself and lots of people thought it would never ever be invoked, and now it's being invoked all the time, and people don't care. What's happened? What's gone on in Canada?
Well, what's happened is what I always knew would happen. Its use has been normalized. There's a famous speech that then Justice Minister Jean Chrétien gave in the House of Commons, I believe in November 1981, in which he said, look, this is only going to be used in the rarest of circumstances, extraordinary circumstances. And he went on to kind of describe what those might be. And that came to be understood loosely as the rare use doctrine. Well, that fell by the wayside very quickly, as I always knew it would. Why do I say that? Well, the first chapter of the book that I edited, I've got is called Chekhov's Gun Inverted, and the basic and it's a play on a phrase about the famous dramaturge Chekhov, who basically said, if you place a gun in the scene on stage, make sure that it gets fired at some point before the end of the act or before the end of the play. And I sort of turned that around and said, if you put a gun in the scene, it will be used. It will be used every time. And that's exactly what has happened. There is nothing in the text of the Charter that indicates or that recommends its use in particular kinds of circumstances. It's not, an emergency powers clause. It's not intended for, it doesn't disclose an intention to be used only in extraordinary circumstances. It is there just as Doug Ford and his then Attorney General Carolyn Mulroney said when they invoked it preemptively with respect to their bill to cut Toronto City Council in half. He said, it's just another tool in our constitutional toolbox. And indeed, that's exactly what it is. As outrageous and unseemly as that would suggest, that's exactly the case. So it has become normalized, and you hear people talking about it all the time. Its use is now generally tolerated. I don't want to say it's accepted, but it's tolerated. You hear even Pierre Poilievre has threatened or even promised to use it if and when he should become prime minister. And it looks likely that will happen. to do such things as to protect legislation imposing mandatory minimum sentences, to prohibit, safe injection sites, and a whole, change bail conditions, bail laws, a whole host of measures in which he said he'll use it, and Parliament has never to date used it. 2 weeks ago, or maybe it was even last week, Premier Legault threatened or promised to use it to ban prayer in public places altogether, in furtherance or in the service of his sort of secularism agenda. So it's been normalized, Brian. That's what's happened, as I always believed it would be.
I'll give you an example. You may not like it because it's far less impactful. But I remember an election recently in Mississauga for mayor, where one of the candidates said that she would never use the supermayor powers because she thought it was undemocratic, and that if you couldn't get something passed by a majority of council, it didn't deserve to get passed. And then the supermayor powers were used 6 times within a couple of weeks. So once you've got a power, even though it's undemocratic and you say you'll not use it, it's a lever to use, and people use it. And
that's a good example.
If you were writing a chapter, or maybe you've got a chapter that says it's smart to have this, what would the argument be in favor of the notwithstanding clause?
Well, if and only if the notwithstanding clause cannot be used preemptively, which is presently not the case, and if the Supreme Court of Canada ultimately agrees with the Saskatchewan Court of King's Bench decision that said that the invocation of the notwithstanding clause does not oust the jurisdiction of the courts to undertake judicial review. If those 2 conditions are met, then I would say we can live with the notwithstanding clause, because in a democracy, so long as we are made aware of what a government is doing, and so long as there is some accountability mechanism in place. In this case, it's not the accountability of Section 1 justification of a limiting or restrictive measure, but it would be the accountability of deliberation both in the legislature before reenactment, or before enactment and before reenactment, and of course, the most important deliberation of all, that in the public square, in the streets, in the press, online. That deliberation is what's critically important in a free and democratic society. And if there's sufficient publicity around the enactment of the notwithstanding clause, with the judicial advisory opinion, if you will, of the impact and effect of a protected law on a guaranteed right or freedom, then there's notice to the public, and the public can undertake an informed exercise of deliberating, of voting, and of supporting measures that the legislature may choose to bring in. I'm still not a fan. You could never get me to write a chapter that says the notwithstanding clause is, unconditionally a good thing. We have Section 1 of the Charter that allows a government to limit rights where it can demonstrate, that the measure, the law in question that has this restrictive effect on rights and freedoms is reasonable and demonstrably justifiable in a free and democratic society. And the court has laid out a very elaborate test called the Oakes test, which requires government to demonstrate that the first of all, to acknowledge the rights limitation, which doesn't have to happen under Section 33, under the notwithstanding clause, to acknowledge the rights limitation, and then to jump through a whole set of hoops showing that such a limitation is consistent with the values of a respect for the is an accountability mechanism that puts government, before the courts. And there's a dialogue between government and the courts, and accountability ultimately for any rights limitation. Presently, that's, if you use Section 33, there's no Section 1 justification required.
We're going to take a final break for some messages and come back with some concluding comments with Peter Biro, talking about this notwithstanding clause and his book on the notwithstanding clause that has just been issued. Peter, remind everyone, what's the title of the book, please?
Thank you for that plug. The Notwithstanding Clause and the Canadian Charter, Rights, Reforms, and Controversies.
Back in 2 minutes. Stay with us, everybody. Welcome back, everyone, to the Brian Crombie Radio Hour. My guest tonight is Peter Biro. We're talking about the Notwithstanding Clause and a book that he's recently published on this topic. Peter, is there any public support for the limits on the Notwithstanding Clause or the elimination of the Notwithstanding Clause that you're suggesting both today and in your book? Because it seems to me like people do not actually care. And if you use our American example, they voted in favor of this autocracy that you're talking about. So do people care?
So, in a democracy, people will care if problems and controversies are brought to their attention. So a lot of us are trying to get people to care, and I hope that we can succeed. I don't want to say I'm optimistic, but I'm hopeful. And we won't get into the semantics of that distinction. I'll give you an example. The Canadian Civil Liberties Association right now is embarking on a wonderful campaign. They call it Save Our Charter or Save the Charter. And the thrust of it is to propose reforms to the way the Notwithstanding Clause is used. And not surprisingly, two of the reforms they propose are, the elimination of preemptive use and the requirement of a supermajority before it can be used. And then they also have an interesting requirement that certainly wouldn't pass muster with the courts right now, but it's very, very interesting. It's the third one. It's the no egregious use reform that they're proposing. Effectively, they're saying that if the Notwithstanding Clause is used in such an egregious way with respect to rights, it should be struck down by the courts. Now, I suspect that what they mean by that is that if the Notwithstanding Clause is used for the purpose of infringing a right, as opposed to being used with an incidental effect of infringing rights. If its actual purpose is to target the right itself, that would be sufficiently egregious that a court should strike it down. Right now, certainly there is no jurisprudence that would support that third conclusion without some kind of constitutional amendment. But I think it's a wonderful idea. I'll give you an example of what I'm talking about. Many, many years ago, there were two cases that were called Sunday shopping cases. One of them was an Ontario case in which the government introduced legislation prohibiting shopping, retail. It was called the Retail Holidays Business Act on Sundays. And the idea was it was intended to give workers a day off. But it incidentally affected people who, observed a different day of Sabbath than the Sunday, and wanted to work on the Sunday. At the same time, there was a case called R and Big M Drug Mart, the Lord's Day Act decision, which actually had the same effect, making work on Sundays prohibited. But the difference was, and it was struck down ultimately, because the purpose of that act was actually to restrict the religious freedoms or to enforce the religious freedoms of certain, religionists, adherents of certain religions, with the effect that it directly infringed the rights of others. So the Lord's Day Act was struck down, and the Retail Holiday Business Act was not. It was dealt with differently. There was a Section 1 justification. There were exemptions. There were modifications. But my point was to draw your attention to two kinds of laws: one that targets the right directly, and the other one that has an incidental effect on the right. And the CCLA certainly wants to ensure that any law that actually targets a right should be struck down as being overly egregious. And but that requires a constitutional amendment, or at least laws in each legislature agreeing to be bound by uh, that
Is
requirement.
there a lesson in the Emergency Measures Act? Because I thought that the way that the courts, after the fact, reviewed the government's justification for bringing in the Emergency Measures Act was actually very helpful. And in the end, I think you'll know better that the court said it wasn't justified.
Right. So
So
there's a yeah, in that particular case, there's a difference between whether the threshold for declaring an emergency was met within the terms of reference in the act itself. All right. And so the question whether it was justified on the basis of simply having met the statutory threshold requirements. All right. And that's one question versus the question of whether it was an emergency that warrants overriding otherwise protected and guaranteed rights and freedoms. So they're two different questions, and I know it's a little complicated, but it's important to keep those separate because the Emergency Measures Act, in its own legislation, requires adherence to or compliance with the Charter. So it's we're not talking about the War Measures Act, that Pierre Elliott Trudeau invoked back in the early 70s. And at that time, of course, we didn't have a Charter of Rights or Freedoms. But we're talking here about a statute that actually lays out conditions which, if met, justify the invocation and application of the Emergency Measures Act, but not without regard to rights and freedoms. So you have to look at the statute.
this is a really interesting conversation, Peter. I look forward to seeing if there's any efforts, any movement, any agreement with your arguments, because I certainly think that the supermajority argument is a very good one. And I'm in corporate life agreeing with, if not arguing for, minority rights on a regular basis, such that minorities have the right to veto things that they think infringe their rights. And a lot of people won't invest in a company in a minority position unless they do get those rights granted. And so, if I can use that corporate law as any kind of comparable, you shouldn't be able to have a notwithstanding clause that's just invoked by the majority. That would be wrong in corporate law. And so I understand how it exists in our liberal democracy. And maybe you're right that we're not as liberal in our democracy as we think we are. Peter Biro, thank you so much for joining us, and thank you for writing the book. It'll be an interesting read for a lot of people, I'm sure.
It's been a great pleasure to be with you. Thanks, Brian.
That's our show for tonight, everybody. I remind you, I'm on every Monday through Friday at 6 o'clock on 960 AM. You can stream me online at www.saga960am.ca. And all of my podcasts and videos are posted on social media. And I'm now getting as many people watching on social media and on podcasts and on YouTube as listening on the radio. So that's a great way to follow really interesting people like Peter Biro and what they've got to say. Stay listening to us on a regular basis, please. That's our show for tonight. Good night, everybody.